welcome to CBank Network. We're so glad to have you here today. Today we have a sponsored webinar from TrueAccord, using Regulation F to maximize recovery.
All the Midwesterners here, I'm not sure I should start the story this way, but my husband's a huge fan of the University of Michigan because he went there. I know this can be fiery for some of the folks in the Midwest who perhaps attended a different Big Ten school. My sister went to Wisconsin, so it's a pretty big rivalry in our family. But the Michigan fight song says like champions of the West. And my kids were like, well, why does it say West? It's in the middle of the country. And so that's when they learned that Michigan was founded a long time ago when that was considered the West. So welcome to using Regulation F to maximize recovery. My name's Kelly Nepper-Stevens. Nepper rhymes with pepper, but it's a tricky one. Let's get started. I have the pleasure of, let's see if I can advance the slides. Oops. So I happen to be a lawyer, but I'm not your lawyer. So I need to say that at the beginning, because while I might be giving advice that seems to be legal advice, it should not be considered legal advice and is not so for this presentation. You need to talk to your own lawyer about that. We're going to talk about a couple of different things as it relates to Regulation F, because I think that the debt collection industry was a little surprised by the rules. Not surprised in the sense of, oh my gosh, this is happening so quickly, because the process to get to the rules took over a 12-year period. But I think that they were surprised at how balanced in some respect the rules were. But then, you know, they were disappointed in other places with how the rules were and weren't sure how it was going to impact their businesses. Ultimately, we have found at TrueAccord that maintaining strong compliance with Regulation F doesn't decrease your ability to recover defaulted debts from consumers. So first, I'm going to talk a little bit about some general principles of digital collections. And then we'll talk about the impact of new laws and regulations, which includes Regulation F, which was the CFPB's effort to modernize the FDCPA, the Fair Debt Collection Practices Act. We'll talk a little bit about the TRACE Act, and then which Congress passed, and it really regulates calls and text messaging. And then we'll talk about some new state laws that are impacting the digital space. And please, if you have a question, just pop it into the question box or the chat box, and I'll make sure to answer it as we're going along here. Happy to share with you some of the things that we're seeing right away. So we know that consumers like digital collections at TrueAccord because we primarily communicate with consumers using digital channels. So mostly email, more and more SMS. And when you're communicating with consumers in these channels, oftentimes it's the way that the consumer was communicating with the creditor at one point, because they signed up for online banking, or they got the mobile app, or they signed up for e-communications because they didn't want paper notices. And so it's not surprising then that when they transition and their loan defaults and they're working with a debt collection company on behalf of that creditor, that at least at TrueAccord, 65% of consumers are opening at least one email. That blows marketing statistics out of the water. And 35% click on the email, the link that's in the email, to go to the linked pages that discuss their debt, that discuss settlement offers and payment plans and how to dispute, etc. New York is the one state currently who has more restrictions on digital. They do require that the consumer consent directly to the debt collector in New York. So in New York, email isn't going to be a successful channel for debt collection, but SMS is. 44% of New York consumers are clicking on links in SMS. And we've also learned, and this is a big discussion with the CFPB during the rulemaking, that, and this should not be a surprise either, a lot of consumers handle their debts and their accounts after working hours, right? When they get home after work, when they've taken care of whatever the needs are of the folks in their home or their fur pets, and they sit down, and then they're taking care of that after 9 p.m. and before 8 a.m. And 8 a.m. to 9 p.m. is the presumed convenient time to communicate with consumers. So for us, we find that when we're offering digital communications, 96% of consumers resolve their account without any human interaction whatsoever. And this can be a real benefit, especially as we all know, having gone through a global pandemic, that having the ability to, work from home and transition from home when your systems are working around the clock 24/7 because they're all automated and online, it can be a real benefit for your business. So we see, and we're seeing now because, for example, the CFPB puts out new press releases every day with their feelings about things in the consumer financial space. In fact, I think just yesterday, they put out a special report that they did on the study of using conditional language in communications with consumers, such as your account may be credit reported versus your account will be credit reported, and the potential confusion that the different terms might have on consumers and the CFPB's preference. Really interesting read if you haven't had a chance to see it. So we see that the regulators are really interested in a variety of different ways to ensure that consumers are being fairly treated in the financial services industry, and certainly in debt collection, right? We know that consumers expect an omni-channel digital experience, so we see the regulators acknowledging that and making clear in Regulation F that it is permissible to communicate with consumers via email, via SMS, when they're in debt, when their accounts are defaulted. We also see at the same time Congress taking action related specifically around consumers being bothered by their phones ringing off the hook. So now you find, and if you have a cell phone, which almost every consumer I think does, that you will get calls. I'll probably get a couple during this presentation, and I will look down and it will suggest that this call is spam, right? So that's the call blocking technology that Congress has requested all of the carriers to have in place. And finally, we have the individual states that are looking at the rules that are out there and their particular consumers and the needs of their consumers, like California, the first state to come out with the privacy regulations that were very similar to the GDPR with the California Consumer Protection Act. New York, as it relates to email. Washington, D.C. just revamped their debt collection rules. It was collection in D.C. during the pandemic was banned, temporarily banned, and the ban is going to lift at January 1 of next year of 2023. And that's when the new laws that they just implemented about a month or so ago will take effect. So we'll talk about that regulatory landscape throughout. So first major principle when it relates to digital is there is no consent required to email. I think a lot of folks think that there is consent. There's no consent required in the law, federal law, to send an email to a consumer who's in debt. Now, New York has an email consent requirement in their provision, and now DC has an email consent provision in theirs, but those are the only two state jurisdictions that do it this time. CAN spam does not apply to debt collection messages. It applies to commercial messages. eSign, the Electronic Global Signatures Act, does not apply to the initial communication that you might have to send to a consumer under the Fair Debt Collection Practices Act. And we got very good case law that talked about that, which is linked here in this presentation. Regulation F, folks have confused the safe harbor in Regulation F with some sort of email consent, and we're going to talk specifically about that. But Regulation F provides a safe harbor for defending against a claim that an email went to a third party. So you sent an email to the wrong person. Sending an email to the wrong person very rarely happens, especially when you're using the email address that the consumer gave to the creditor, right? Folks don't change their email addresses like phone numbers. So it's not like a reassigned number database problem, especially because even though a consumer might change their email address, old email addresses are never reassigned to consumers. And so the Regulation F didn't do anything to change the fact that there is no consent required to email. And I put a quote here from Regulation F that makes clear where the CFPB acknowledges that. There's no consent required to send text messages by a system that is not an automated telephone dialing service. And under the TCPA, consent is required if you are using an ATDS to text or call a cell phone, or if you are leaving a pre-recorded message. The pre-recorded message bit is important because it doesn't matter how you deliver a pre-recorded message. A pre-recorded message requires consent under the TCPA. But to send a text message, if you are sending that text message on a platform that is not constituted an automated telephone dialing system under the ATDS, you don't need consent for that. I have not seen a financial service product, loan, credit card, small dollar loan, fintech loan that does not capture consent directly from the consumer at the time the consumer is originating or applying for that account. All of the terms and conditions that I've reviewed typically obtain at that time consent to use an automated telephone dialing system to dial the consumer, to text the consumer, and even to leave a pre-recorded message. And sometimes it even spells out in the event your account goes into default, we're going to do these things and we're going to pass this on to our debt collector. But that consent is not required if the system being used is not an ATDS. And there was a great case that came out of the Supreme Court just last year in 2020. It was the Facebook case. And the Facebook case, essentially, Facebook versus DeGuid, you can see here at the bottom of the slide, made clear that an auto dialer must have the capacity to use a random or sequential number generator. So this is really important, especially for a lot of companies out there who don't have that as a feature in any of their communication platform delivery services that are delivering text messages and that even are delivering phone numbers. So real important concepts. All right, so let's talk a little bit about Regulation F. Took effect on November 30th, 2021. It doesn't change the rules in the Fair Debt Collection Practices Act. It actually adds to the rules in the Fair Debt Collection Practices Act. And we're going to talk about those additions as we continue. And again, if you have any questions, throw them into the question box. I think what's most important is definitely check out the Small Business Compliance Guide if you haven't yet, and definitely check out the frequently asked questions, because if you have a question that wasn't answered yet, it might be answered in the FAQs. And that FAQs, they're updated all the time. And oddly enough, the last update, which occurred in July, was not publicized by the CFPB. Very odd, because they seem to be publicizing a whole ton of stuff and all their activity lately, but they did not publicize their changes to their FAQs. And the FAQs solved some big questions that were out there and that are driving lawsuits right now. So great answers that they had there. We are beginning to see Regulation F lawsuits. I have a handful regarding unsubscribe. I have whether or not it's clear and convincing and whether or not we're abiding by a consumer's request to unsubscribe. Have a handful regarding the model validation notice. And then we've seen several out there with the call restrictions, the 7x7 calls. I haven't seen a significant uptick in any complaints related directly to Regulation F. The majority of complaints still in the debt collection space are related to consumers who are disputing, consumers who are asking questions about credit reporting, which in all honesty, I think is more of an inquiry than a complaint, because they're not complaining about the companies themselves. They're saying, hey, I dispute this debt, which is a separate process that those companies are going to follow. They're just notifying them through the CFPB. And then the rule also made clear that no consent to email, no consent to text. They did put out the requirements that they want to see if you are sending required required disclosures electronically. And they also, there is no waiting period to email required in the rule. I hear a lot of people talking about the waiting period in the rule. It's not a requirement. That's their safe harbor, and we'll talk a little bit about that as we go along. TrueAccord was very active in the rulemaking process. We served on the small entity review board business panel in order to provide feedback as a small business. And we provided a lot of data separately as well, because we were one of the only companies in the industry using digital. And so the rule that resulted kind of largely mimicked our practices, and I'll walk through and show you how that works. So these are kind of the big hits that are important to be aware of, where the rule was extended or clarifying what we saw in the FDCPA itself. So FDCPA prohibits communicating at a time that is inconvenient for the consumer. If you don't know when it's inconvenient for the consumer, the FDCPA says you have to presume that it's inconvenient before 8 a.m. and it's inconvenient after 9 p.m. in the customer's time zone. And they made clear that this is what changed in the rule. You have to assume that the consumer's in all locations that you have for them if you don't know. So if you don't know where the consumer is located, you need to assume they're in both locations. This can be problematic if you're, say, someone like me. I live in Virginia. I have a Virginia zip code, but I recently moved from San Diego, so my phone is the San Diego area code. So you're going to have to presume that I am a consumer in both locations when you're reaching out to communicate with me. The CFPB did not provide any information about whether or not the knowledge about where the consumer is located could be garnered by where that IP address is coming from, right? You can learn that a consumer is pinging from an IP address in the Eastern time zone. Can you then update your system to reflect, we now know this consumer is in the Eastern time zone because that's where they're pinging us from when they're opening up our communications. And so here's some examples for inconvenient times. They went through great pains to map out, okay, if you find out that a consumer does not want to be called on Tuesdays from 3 to 5, you can't call them on Tuesdays from 3 to 5. And this is what they recently updated in the FAQs. They said, hey, if they tell you they don't want calls from 3 to 5, that probably also means, or if they're not specific, they say, don't contact me between 3 and 5. You need to not contact them between 3 and 5. You can't presume that's calls. If they specify and say, I don't want calls from 3 to 5, you can send an email. But if they don't specify, you just have to presume that they don't want any communications between 3 to 5. So lots of examples cited in the rule, and examples too, like if the consumer says, don't contact me at home, you can't send letters, you can't call the home phone number, but you may send emails or text messages even if the consumer receives them when they're at home, because those emails or text messages are typically going directly to the consumer and not necessarily to the house where someone else might answer that home phone line or get the mail. Passing inconvenient times and channels is really super duper important. And that is because you are not required to pass inconvenient times or channels that one debt collector learns to the next debt collector. And this is because the CFPB made very clear in the rule, a consumer might feel very differently about communicating with one debt collector via email or phone than they would about another. So, and they made clear that the final rule does not require that you have to transfer this information regarding inconvenient time. There's been a lot of discussion about, well, does that mean that we're still like off the hook then from a UDAP perspective, or do I have to have a UDAP policy that's going to require me to transfer this information? Well, that's really a question that's up to the individual companies themselves and your risk tolerance as it relates to this. But you do have a lot of examples in the rule where you have words from the CFPB in very different sections, like this is page 101 and also page 335, where they're talking about how, you know, different debt collectors are different, creditor debt collector is different, and there's no requirement to actually pass this information along. Communication frequency. So we have the 7 and 7 rule, which is the call rule, right? So you can only call 7 times per week per account. Now we don't make a bunch of outbound calls, so this was not an issue for TrueAccord because we're primarily digital. There was a lot of pushback from consumer advocates that said, hey, CFPB, you didn't put a restriction on digital communications. And that's a harm for the consumers because now these debt collectors and creditors are just going to jam the consumers with email communications or SMS communications. However, that's just not true and would be against the law. There is a harassment provision in the rule itself, right? You cannot harass a consumer by sending multiple communications. Before, you know, emails and text messages began to be used so frequently, they only had phone calls, and you only see a lot of lawsuits with phone call information about how many phone calls is too many phone calls. Well, Reg F made clear 7 phone calls per week per account, that's the max. And they also made clear that harassment is based on the totality of the circumstances. So you have to take a holistic approach for all the channels that you are using so that you are not bombarding the consumer across the board, across your different channels. So it's something that everybody needs to be thinking about. And the fact that they didn't put in a specific hard number for emails or text messages really isn't that problematic for the consumer, because there's really some protections that are built in to email and text message in and of itself, right? So there's the carriers who, for email, they are monitoring for spam. And if it looks like you are a spammer, they even give the consumer the option to tag an email as spam. So if you're sending too many emails, you get tagged as spam, your deliverability is going to go down. The more your deliverability and domain score kind of goes down, the harder it is going to be for you to deliver emails successfully into a consumer's inbox. If you're in their spam box, they're not going to see you. They're not going to engage, and you're not going to collect on the account. So you have to be very careful and strategic about when you are sending communications in order to make it into the inbox, in order to not get tagged as a spammer, because an annoyed consumer isn't going to want to interact with you anyways. And that's the same, regardless of whether you're using email, text message, phone calls, etc. Right call, right channel, or right time, right channel, right message is what you need to engage the consumer. Record retention, 3 years. So that's important to keep in mind. California is thinking about changing that law to 7 years. It's caused a bit of a hullabaloo. New York has some provisions as it relates to their security and information security laws that require you to retain data for 6 years. The TCPA statute of limitations is 4 years. But at least for Regulation F, we have a 3-year record retention rule. All right, so let's talk specifically about email. Here are some general email practices that came out in the rule that are super helpful to know. Number 1, email occurs when the debt collector sends the email. This is good to know, right? Because there's all kinds of timing requirements. And so it doesn't matter when the consumer opens the email. The email is sent when it's sent by the debt collector. Unsubscribe has to be clear and conspicuous. So if you're using an unsubscribe feature in your digital communications, stop to opt out needs to be very clear, very conspicuous. And then the last part about general email practices relates to the electronic communications and sending disclosures electronically. So disclosures are going to be any federally required notice that you need to give. In order to do so, you have to make sure that you're doing so that the consumer can keep and access those disclosures later. That includes 3 things: monitoring the deliverability of the email, knowing whether or not it hard bounced and was sent back to you and didn't even make it into the inbox, identifying the debt collector as the sender of the email, not hiding who you are, and then having 2 pieces of account information in the subject line. Okay, so this is interesting because we have this whole set of envelope window cases where if you can see anything through that glassine window, and they're actually ridiculous cases if you haven't heard about them. The glassine window cases, like there was a QR code, and if your neighbor goes into your mailbox and scans your QR code and figures out that you're in debt collection, then that's a violation. That's a third-party disclosure. Those came out of the Third Circuit. And they seemed a little bit crazy. And so as a result, a lot of people were like, what? I should put 2 pieces of account information in the subject line? It's kind of like the window envelope, except email is way more private, right? You have to log in to get to your email. So it's now a requirement. And this actually was interesting because the judge in the Northern District of California, very liberal court, who heard the TrueAccord versus Green case, which was about successful delivery of the initial communication, said it's important that it gets called to the consumer's attention, because if it has these important disclosures in it, as a consumer, you want to know. Apparently that judge or his wife or someone shops a lot at J.Crew, and he's like, my inbox is slammed with J.Crew messages, so I'd love to, when it makes it very clear what the message is that's coming through, especially if it's from a sender I didn't know. So that makes sense as to why the CFPB would then request those 2 pieces of account information in any email that you are sending that contains required disclosures. So here are some examples, right? Here's an example of an unsubscribe button. It's highlighted blue because you can click on it and it'll take you right to the unsubscribe flow. TrueAccord identifying yourself as the sender of the email. And then here's the unsubscribe page, right? So the unsubscribe link takes you directly to an unsubscribe page that explains the unsubscribe process. And then you see orange for unsubscribe, green for view my options, click on unsubscribe, the account information is going to be unsubscribed immediately. And here is the example of, oh, interesting. I'm like, why isn't it showing up? I guess I had a toggle there. So the unsubscribe request should show up clearly so the regulators can see that you are processing that unsubscribe. And same thing with like hard bounces, which we talked about earlier. You want to know if you get a hard bounce. You need to have a hard bounce policy that explains what happens if an account hard bounces. If an account hard bounces at TrueAccord, we do not assume that the consumer received it because we know they didn't receive it. But you also need a policy for a soft bounce, because a soft bounce means you're not sure that it was delivered. Your sending email domain is not sure if it made it to the domain of the consumers. And so you know, you need to have a process to make sure that you continue to attempt to deliver, especially if it's a required disclosure, because it hasn't been given for sure on a soft bounce. And so one of the Regulation F cases that we received very early in the year was a consumer who said that he unsubscribed and that we did not properly address that consumer's unsubscribe. That case was filed in Texas, and I was very excited about it because the consumer unsubscribed the day he filed the lawsuit. Previously, he had gone to the unsubscribe page, and the record reflected that he clicked on the link and went to the unsubscribe page, but he didn't unsubscribe. And so one of the things that we do is that if a consumer, you know, falls off a page and doesn't do something that was on the page that they were looking at, we'll send them a notice to say, hey, did you want to unsubscribe? We know that you were on the unsubscribe page, but you didn't successfully complete the unsubscribe process. If you wanted to unsubscribe, this is how you do it. We explained it. So the consumer got that email, and then he went ahead and unsubscribed officially after opening and receiving that email. And then he filed the lawsuit saying that we emailed him after he unsubscribed. But again, he dismissed that lawsuit because he had no claim. Once he officially unsubscribed, our records reflected that we got the unsubscribe request, and then there's no communications to the consumer after that. Examples of policies you want to have in place relating to monitoring deliverability and unsubscribes. So there is consent required in 3 instances in Reg S. So there are 3 instances where the law interacts because of the e-Sign Act and even the Electronic Funds Transfer Act, so Reg E, that would require you to have consent to send an email to the consumer. So the first one is anytime the initial communication does not contain the validation notice. So let's say your initial communication was an email, you sent the initial communication, and then great, it didn't hard bounce. You can continue emailing with the consumer. Their initial communication was an email. If you hadn't sent that email out and the consumer called in to your office, if you don't read them the validation notice during that call, then that call was the initial communication. It didn't contain the validation notice. And now you have 5 days to send them the validation notice in the mail. And that's where the e-Sign Act is triggered, because the e-Sign Act says anytime you have a federal statute that requires you to send something to the consumer by mail, you have to obtain e-Sign consent in order to send it to them electronically. So you don't need consent for the initial communication that contains the validation notice. But if your initial communication did not contain the validation notice because a consumer called in first, and when during that call you don't read them the validation notice, then you do have to during that call say, hey, can I have your consent to mail you or to email you the validation notice? And then you need to send them the e-Sign disclosures as a part of that. The other 2 instances are when a consumer disputes the debt. So when a consumer disputes, you're supposed to mail them the debt validation documents. There's that mail trigger, right? So because the mail is triggered, e-Sign requires you to capture consent. So you want to capture consent when a consumer is disputing. They're on the phone, you want to capture it, you want to save that call recording, and then you want to send them an email with the e-Sign disclosures, reminding them that they consented. And same thing with payments, right? Because the Electronic Funds Transfer Act also requires certain payment reminder language to be given to the consumer. So to send it electronically, you have to capture consent, and you can do that through, you know, whether you're capturing payments in an IVR or if you're doing payments to your online portal, you can provide those e-Sign disclosures. So here's an example of how we do it. And, you know, a little bit more detail. If somebody calls in before they got the email with the validation notice. Then we're going to capture consent over the phone. It's going to be recorded. We save our telephone recordings now for 3 years because of the record retention requirement. And then we send an email confirming and providing the electronic e-sign terms. And you can see here, this is our online flow. So if a consumer disputes, they're beginning the dispute process, they have to check this box and agree to the e-sign terms. But if they want to have their validation mailed, they need to call into our office so that we can process that dispute. Payments, same thing here. By checking this box, you acknowledge that you've read and agreed to the payment terms and the e-sign terms, right? So you can capture it via the online flow. You want to make sure, because we've seen the CFPB talk about dark materials. I feel like it's dark materials. That might not be the right word specifically, but if you're not really giving the consumer the terms that they need to understand what they're consenting to, the CFPB is going to have a problem with it. So you want to make sure that you have a checkbox and that you're telling them what they're agreeing to right there. All right, SMS best practices. So SMS, you got to have that reply stop to opt out of SMS. You got to have a way to monitor and make sure that when someone's saying stop, I don't want to get a text message anymore, that you're not texting them anymore. An annoyed consumer is not going to be a happy consumer. They're going to go make complaints. They're never going to pay. So having these things out there and allowing consumers to opt out and tell you their channel of preference is really beneficial for you in the long run. And then also with cell phones, because consumers might change phone numbers and phone numbers are reassigned, from a consent perspective, it's important to know if you are obtaining consent or you are using an automated telephone dialing service to deliver text messages, you need to know who's consented and who hasn't, and if the number's changed. You also need to know if the number's changed from a Reg F perspective, because you don't want to send a communication to the wrong party. So really important that you're doing a reassigned number database scrub. There's been a lot of information about the reassigned number database that's recently come out. They reduced the pricing because originally the pricing was outrageous. It's still pretty expensive. And I've heard that actually the reassigned number database isn't that great, but I'm not sure what your experiences have been with it. Would love to know, but it's important to include. What's important for linked pages is that you're making sure that you're getting all those state disclosures on the page so that the consumer is getting the disclosures that are required to be on any communication. So there are multiple states that have requirements for every communication that a consumer gets. And so as long as you can show that it's linked in the flow, we have a court decision that came out of New Mexico, federal court in New Mexico said that anything linked in the communication with the consumer is something that is taken into account in the totality of the circumstances of what the consumer's understanding is. So that's why we put all the disclosures on the page that's linked in the SMS message. So here's the SMS message. They click on this link. It sends them to perhaps this page, right? We have a message for Shannon B. Click here to see the message. So you're doing some authentication. And then Shannon, here's more information about your balance, and here are her options. And then here we have the message. And again, if you kept scrolling down, you would see at the bottom, dispute this debt, unsubscribe from SMS and privacy policy. So want to make sure that you have your unsubscribes on any electronic communications that you are sending. So social media best practices, Reg F made clear you can communicate with consumers via social media, but you can't do it publicly. You can only do it in a private manner. We don't communicate with consumers in a proactive manner. We do advertise on social media. So, you know, how that would work is we'll take a list of email addresses that are consumers that are in our system. We'll give that email address list to Facebook, and then Facebook may or may not, because they don't tell you which one, put an ad on their private feed about TrueAccord. And then if the consumer were to, you know, click on the link, it would take them to TrueAccord's Facebook page. This is mostly for brand awareness, for making consumers aware, hey, you got an email from us, go check out your email, check out our company to confirm that we are a legitimate business, you know, accredited by the BBB, not a spammer, right? So not fraud. This is legitimate. We're contacting you about a legitimate debt. We don't really get into conversations about their debt. We still go ahead and put the mini Miranda just to make sure that, you know, to the extent that anyone thought this was a communication about the debt, it's there. But this does not link them to anything about their account. It only links them to, you know, TrueAccord's Facebook page. When you're on social media, the consumers will come to you. So if your business has a Twitter page, if your business has a Facebook page, you will find that consumers will reach out to you in that fashion. A couple of years ago, we had a consumer reach out to us on Twitter, said, hey, I need to not make my payment today that's scheduled. How do I stop that from happening? Now, we could not tell who the consumer was from their Twitter handle. So we had to tweet back out to that consumer. If anyone was interested in canceling a payment plan, this is how they would go about doing it. Please reach out to us directly. This is how you can reach us. And that's when we realized, we need to have pre-approved answers for these types of questions that might come in on social media to make sure that we are responding to the consumer's need in their channel of choice, which this consumer chose Twitter, and giving them the information they need while not publicly communicating about an individual debt. So that's how we've been handling those sort of communications that come in. So Regulation F has several safe harbors, and the question is, are the safe harbors worth it? So the first safe harbor I want to talk about is the model validation notice. The industry was craving a model notice because if you use the model notice, which is contained in the debt collection rule, I printed mine out. I keep it here. This is only half of the debt collection rule, though. Don't think it was this short. The model notice, which they put on Appendix B, is a letter that you can use. And if you copy this model notice and yours is substantially similar, then you get the safe harbor and you're immune from a lawsuit saying that your validation notice was insufficient. So we're seeing a lot of consumers that are using the tear off portion in this letter in very confusing ways. So they will send in full payment, but yet the tear off itself, they'll dispute the debt in the tear off. And so companies are having to develop policies around, okay, well, what am I going to do when I get full payment and a dispute at the same time? Do I take the payment and then get the consumer debt validation documents? How should I handle that? We also are seeing a lot of lawsuits about the model validation notice. So for example, this is all the new information. Anything in red is something new that needs to appear on the model validation notice. So a lot of things have been added from just the standard validation notice that we had in the past. But it also made the validation notice a lot simpler and easier for the consumer to understand. It changed the mini Miranda. So here is TrueAccord's letter. We sometimes send a letter, particularly if the consumer's in New York. So you'll see this consumer's in New York, because you cannot send the communication by email unless the consumer has opted in to emails with the debt collector. So here's the tariff I was talking about, where the consumers sometimes are disputing and also sending in a payment. Some of the other things you need to have on here, you need to have your itemization date, and from the date of itemization, you have to provide the amount that has been added in interest, the amount in fees, and any payments or credits that were applied toward the debt. And then you have to tack it out and tell them what's due now, and it all has to add up very nicely. You can itemize from one of 5 dates. They're all right here. Most folks in banking itemize from the charge-off date, or maybe the date of last payment. Last statement date is sometimes difficult, depends on your particular business and how you're keeping your records. And it was a big lift for all companies to figure out how to pass this information back and forth and get this information on these new initial communications. Of course, New York had already had an itemization that was supposed to be on. So some companies were ready to go because they'd already been doing this for the state of New York. You also have to add another date. You have to calculate when the consumer's validation period expires, right? So the validation period is typically 30, well, not typically, the validation period is 30 days from the date the consumer receives the letter. That's what it says in the FDCPA. I'm pointing to the FDCPA because it's typically right there under my computer. I keep it because I look at it so often, and that's why mine's actually fallen apart. That's how often I refer to it. But it does require 30 days after the consumer receives the validation notice. That's their dispute timeframe. Most companies don't care when a consumer disputes, because ultimately, if a consumer's disputing, they want to show them, hey, this is why we think you owe what you owe. Do you think you owe something different? And if so, why? Prove it, and then we'll get, you know, on the same page, right? And then move forward. So most companies don't really care, but either way, it's in the law. So we have to comply, and we have to put a validation expiration period here. And so you have to do 30 plus 5, because you have to exclude holidays and weekends from the date that you send the initial email or letter. You might need to build in more time for the delivery. The initial communication can be done electronically. This is our electronic version. This is also a New York consumer, so it has all the New York disclosures here, and you can see all the New York disclosures appear on the back of this one. There's a new lawsuit I was reading today about how the itemization on the front didn't match the itemization on the back. Of course, it was a New York account, and so someone's getting sued. Also, the CFPB did not put a date. So if you look here, they didn't, of all the things that they wanted, they didn't put a date. So a lot of folks were getting sued because they didn't put the date that they sent the communication. Kind of crazy. The FAQs resolved that, and they put a date. The CFPB said it's okay to put a date. Go right ahead and do so. A lot of the FAQs are very common sense. This was something that came out through the FAQs. How do you itemize if there's multiple debts? There are ways that you can do so. So you can refer to this slide to see about that. And then that kind of concludes the, wait, did I miss the, So that's the model validation notice. Definitely worth it to take advantage of that safe harbor. The number one reason why debt collectors often see lawsuits is from that initial communication letter or notice. And so having the safe harbor offers protection from one of the biggest drivers of litigation. And since they allow you to do so electronically, and when you do it electronically, you can have hyperlinks, it really makes it quite easy and a no-brainer. Third-party disclosure email safe harbor. So this one is one that we don't take advantage of at TrueAccord because domains don't reassign emails. So essentially what the third-party email safe harbor says is you get a complete defense to a consumer who claims you emailed the wrong person information about my debt. So you can't disclose a consumer's debt to a third party. If you do, it's a violation of the FDCPA. So I guess the CFPB was worried about emails going to the wrong person. Well, we've been emailing a lot of consumers, like 20 million at this point. And we've had like a very teeny, like a handful of claims related to this, because ultimately at the end of the day, consumers don't reassign, the email addresses are not reassigned. Number one, they're just not. And number two, consumers don't change their email addresses, right? And very few consumers share email addresses with their family members. We did have someone claim that. Their claim was that, kstevens@gmail.com, that was pretty much close to that consumer's email address, was shared with her roommate, whose name was like, I don't know, Peter Klein, right? And we were like, really? kstevens@gmail, you just share that with your roommate, Peter Klein? And that lawsuit ended in our favor, right? They dismissed, they didn't move forward. And that the email safe harbor is pretty complicated because it requires that the debt collector gets the email directly from the consumer. That's one way. Or number two, that the creditor got the email from the consumer. The creditor used that email to communicate with the consumer successfully. The consumer never opted out of email with the creditor. The creditor sends a warm transfer to the consumer saying, hey, we're transferring your account to such and such a debt collection company, and we're giving them this email and this telephone number for you. If you want to opt out of emails, please let us know in the next 35 days or so by doing the following. And then the consumer doesn't opt out, and the consumer doesn't have a private domain name, a .org, a .gov, a .edu, a .com, right? I mean, like Gmail is okay, Yahoo is okay, but like a business email would not be okay because that could be a work email address, right? And so they're trying to ensure that you're not sending emails to a consumer's work email. That's the third-party disclosure safe harbor. And because it's so onerous and doesn't really, we don't really have an issue with this. We don't have these sort of violations. We did not implement this safe harbor. All right, next safe harbor, SMS. because phone numbers are reassigned, it makes more sense to follow the SMS safe harbor disclosure. Again, it's a defense to a third-party claim. There's two ways that you can use it. Either the consumer texts you directly, and then you're sending the consumer a text or you're sending the consumer text and they're responding to you, or you're checking that it hasn't been reassigned, right? So this is, again, getting to the fact that phone numbers are reassigned. And so you always have to be checking that that phone number hasn't been reassigned if you're taking advantage of this particular safe harbor that's in Reg F for emails. And then the last safe harbor that's in the rule is the limited content message. The limited content message is kind of useless because it sounds like spam. It's leaving a consumer a message that's like, hey, I'm Kelly Stevens. I'm calling from TrueAccord. Contact me or Jim Johnson at this phone number. No one's going to call you back with that message. Now, voicemail drops are debt collection communications conveying information about a debt. You could certainly use that as long as you had, well, you'd have to evaluate the technology, and we can talk about that if folks have questions. But ultimately, we chose not to take advantage of this particular safe harbor. We use a variety of different messages to try and trigger consumers to go look at their emails or other messages that we're sending them. And the rule makes clear that you don't have to use a limited content message. But if you use the limited content message, then you get safe harbor from someone saying that you disclosed to a third party. And this is attempting to answer the answering machine conundrum that occurred, in the 90s when answering machines were like a thing. I haven't been to anyone's house lately that has an answering machine where you'd hit play and your roommate or your kids or anyone who was in the vicinity would hear the messages that were being played. And we created that FODI message, like pause. I'm trying to reach Kelly Stevens. I'm going to pause for 10 seconds here so that if you're not Kelly Stevens, you can hang up. And then they would leave the whole, debt collection spiel. But who would hang up? Like no one. You're going to want to know what's the secret message? I want to know. So anyways, it's attempting to solve that problem, which was a big problem. So the industry's, glad about it. The problem is the message that they've given us is not going to be very helpful with the consumers today, especially with this law. So ultimately, with the call blocking tools and the stir, shake, and authentication tools, it's getting more and more difficult to call and reach right party contacts on the phone. That's ultimately the story as it relates to the TRACE Act. And, the FCC had an order that came out last December of 2020. It removed the exemptions from pre-recorded business calls so that now you're subject to the 3 calls per 30 days to landline phones without consent. And then we see in the news quite frequently all kinds of issues with the different telephone carriers who make statements about whether or not they're going to allow debt collection communications through their network. And we know that T-Mobile came out in 2020 and said they're not going to allow debt collection messages. And so it can be very difficult when you're applying for a short code, if you're a debt collector, to get a short code, particularly because of companies like T-Mobile. And we know that the American Collectors Association is working vigilantly to try and assist with that. Talk about some of the state laws in my last 3 minutes here. I don't see any questions, but if anybody has questions, please pop them in the chat box. New York has had some issues because they passed a law that changed the statute of limitations, went into effect in April, and then the industry's like, hey, by the way, now the way in which your statute of limitations law reads, it makes the disclosure that you require us to give on out of statute accounts wrong, because now the disclosure that you require us to give doesn't match the law that you changed. So New York Department of Financial Services came out and said, oh, yes, here are the new disclosures you can give. We're giving you this guidance on these FAQs. Use these disclosures, and we'll go ahead and amend that law very soon. And then they are also in the process of updating their debt collection rules. Their debt collection rules are the ones that do require direct consent to communicate by email. They're seeking to add direct consent to communicate by SMS. They're also seeking to limit calls to 3 per week. And then they also want to ensure that the initial communication with the validation notice is provided by mail unless the consumer directly requests it electronically. which may mean that once you send the debt validation by mail, then you can communicate in email, but we'll have to wait to see how that rule plays out because it's right now in a proposal stage. They have a couple of other debt collection regulations that have come out, not purely digital, but just wanted to call them to your attention since they did just take effect. And then DC, which I promised I would talk about, they just updated their law. It takes effect in January, 4 calls in a 7-day period. And then they also put an email and SMS cap. You can send 1 email or SMS or private message via social media per week until you capture consent. So you still can communicate electronically, just only once a week, no matter what type of way in which you're reaching out electronically until you have consent. And then once you have consent, no more than 5 per week. And so, just goes to show, like, one state passes something, another state's gonna be like, oh, that's a good law, I'm gonna pick that up. So, we see that happening a lot. California, always updating their law. And Utah updating their laws. I mentioned earlier, there's debt collectors, and I think it was all consumer financial businesses to keep records for 7 years, which is interesting because that sort of conflicts with data protection laws. Like, why would you want to keep personal data longer? Anyways, and Utah following with California and Virginia and Colorado, right to know, right to delete. I'm at the hour.
That was excellent, Kelly. Thank you so much. I am going to quickly launch a poll just for those. I'm mindful of the time, and I know people have hard stops sometimes. So if you would like to hear directly from TrueAccord, please do let us know, and we will share your contact information with them, and they can reach out to you. So questions, we do have a few that have been, lots of thanks. Yeah, that was an incredibly informative presentation. So, and I was asked by a few people about the recording. So just briefly, I want to go over that. The recording and the presentation materials are available to you. The presentation materials are available to you right now in your cbanknetwork.com account. The recording will be available to you in a few hours. Give us a minute and we will have that edited and uploaded, and you can go to your cbanknetwork.com account, go to view education, select orders. In the orders section, you can scroll down to this particular event. It should be at the top. Open the event, and the video recording will be right underneath Kelly's picture. So you can watch that as many times as you would like. And yes, agreed. All of these excellent presentation comments are rolling in. So go ahead.
I saw a question that you put in the chat. I'm sorry, I had the question box open, not the chat box. But as a bank who collects on our own debt, do you recommend that we send a validation notice? So I'm talking only about the FDCPA because the state laws may differ. So there are states that might require you to send a validation notice when you are the creditor who originated the debt, like California might require that. But the FDCPA definition of debt collector, and it's the debt collector that has to send the validation notice, excludes those who originate the account. So if you are an original creditor and the debt was you originated the debt, right? Then you are excluded from the FDCPA. You do not have to follow Regulation F if you are collecting on the debts yourself. So that's my answer.
Perfect. Thank you, Kelly. So I'm going to go ahead and flip back to my hold screen. You see the TrueAccord contact information there. You are always welcome to contact support at cbanknetwork.com if you would like to get a question to Kelly. A huge thank you to TrueAccord for sponsoring this webinar today. That was Kelly Knepler Stevens.
Nepper, that's right. Nepper, Ryan Pepper.
Using regulation F to maximize recovery. Thank you all so much for joining us, and I hope you have a wonderful rest of your day and a wonderful weekend. Bye, everyone.